Let's continue. Deputy Director, please. Chairman, I was talking about the Advisory Council on the Environment's views. Basically, the ACE generally supported the REE regulation and the PERO, and they have also given us some comments, and they believe that the licensing control would facilitate proper recycling locally and bring opportunities to the industry, and would also enhance the import and export control of waste. And they also note that some existing recyclers might not be able to meet the new licensing requirements. And then at the last meeting, Chairman, there was a discussion on the implementation timetable of the new licensing regime, and our plan is to introduce this new licensing regime at the end of this year, and also the import-export permit control. But having considered views of the trade during the public hearing, we considered that more time should be given to allow them to prepare for the commencement of licensing control. Meanwhile, we understand that some operators of the trade may need more time to meet the licensing requirements, for example, to obtain prior approval of the Town Planning Board or the relevant departments in meeting the requirements. Having considered these matters, we would consider deferring the commencement of the new licensing regime so that the trade can be more prepared. But in terms of the import-export permit control for e-waste, the commencement date would remain unchanged, and that is by the end of this year. And at the last meeting, some deputations expressed views and concerns on downstream and upstream arrangements, and our response is set out in Annex 8. And in Annex B, may I also point out that having considered various comments, we are going to make amendments to the regulation. There are three main points as set out in Annex B. The first point is that the seller, in our original plan, is that they must specify 3 collectors in his removal service plan, and the trade's view is to increase the number of collectors, and we therefore will amend the number of collectors to be specified from 3 to 5. Second point, according to some views, if the collectors specified above cannot provide removal service, whether the seller can provide the service himself, and will also allow the seller to provide removal service under certain circumstances. Point number 3, we have considered a suggestion in relation to the time frame for the provision of removal service, and originally the consumer should make a request for removal service within 3 days of receipt of goods, and the suggestion was to advance this time frame such that we are going to amend the requirement, and the consumer must make this request at the time of receipt of goods. Because in practice, when the consumer purchases a piece of electronic equipment, the consumer would usually request for removal service, and the seller should therefore provide the service accordingly. So that concludes my summary, and members would like to ask questions. Mr. Gary Chen, followed by Mr. Ted Hui and Mr. Leung Chi-Chao. 4 minutes each. Thank you, Chairman. Well, just now you mentioned the new licensing regime will be deferred in terms of its commencement, but I think you need to get this technical point here. You're going to continue to receive applications for a license. Well, say for Alba IWS, if the application is successful, then under your regime, the Alba IWS can be a licensee and can provide a service under the law. Is that correct?
Secondly, you can postpone the commencement to a later day and allow room for the trade, and I think that is acceptable. But can you tell the committee when the commencement will be, extended? What I think if we give you our agreement and we only implement this 3 years later, that would not be acceptable. So this is my position. Apparently the trade is not concerned when, but as to when they will not be allowed to operate if they don't have a license. I think that is the concern. Deputy Director, Mr. Hui's understanding is correct. On June the 19th, the application date will stay. So starting from June 19, we will start accepting applications. For some applicants, after they put in the application, they have received a license, and then we will issue them the license accordingly. But by the extended date I mentioned earlier, that is when the new control mechanism will come into place, we will postpone the commencement date. As to when, we now decided that we would like to take a look at how long it would take for the application to be processed, and we will actively consider what the impact will be if we were to postpone the commencement date so that we can allow more time for the trade to apply. But as by how much we extend the deadline, we will look at the time required for the vetting of the applications. Chairman, at the hearing, the trade mentioned that they raised the issue of rent because they have signed leases for a few years. So if you want to work with the trade, are you going to really allow them a few years? If that's the case, I find it very unacceptable. So you've not given us an accurate date. Could you tell us what are the concerns of the trade, whether it's the rent or what? So what is your main consideration in deciding the extension? One of our considerations, as I said earlier, is that the applicant may need to apply clearance from the Town Planning Board to allow them to change the land use. And we need to consider how long the Town Planning Board will take to consider the application. We will decide on by how much we will extend the deadline after taking that in consideration. For some individual cases, it may take longer, but we will not only consider, we look at it only in the light of a single application, but we'll take a look at how long it would take before the relevant clearances could be obtained. I agree with the extension, but I don't agree that you do not set, a definite date. So there might be other regulations regarding license applications, and also when will be the cutoff date, and if an applicant has obtained a temporary license and before the cutoff date or before the deadline, his application for change to the land use is still being processed. At an earlier meeting, the Deputy Director said that there will be an arrangement to issue a temporary license so that the applicant can continue with his operation. I think the question raised by the trade, it's about when will be the deadline, and secondly, they would also like to know about the details regarding the temporary license. Thank you, Chairman, for the question. In our paper, I did not particularly highlight this one earlier. Now, if the commencement date, regarding commencement date, if we believe that we need to postpone that, and after we postpone the commencement date, I don't think there will be any need for temporary licenses anymore. In the majority of cases, we would already have considered the time required for the clearance to be obtained. So if the trade has to apply, I'm sure such application would have been processed already. So in the paper, we're saying that if we're going to postpone the commencement date, the applicant will need to satisfy all the licensing conditions before we will issue them with a license. Another point I'd like to make is that go regarding the commencement date. There will be another notice of the commencement date. Of course, this committee will not need to deal with that notice. Later on, if we decide to postpone the commencement date by a year or a year and a half, then the relevant notice of commencement will be vetted by this council again. I think the question raised by our member was that the trade may take time to apply for a license. They worry that if the deadline, if the cutoff date is too early, then you will jeopardize their operations or livelihood. And I understand Mr. Hui Chi-fung's point is that you shouldn't, the commencement date should not be postponed, by a long period of time, because we would like to regulate the operation as soon as possible. But if there are individual examples, on the one hand, we don't want the commencement date to be postponed by too long, but there are, on the other hand, circumstances in which the applicant may take longer to apply to the town planning board before clearance is granted. So in such circumstances, will there be arrangement for temporary license to be issued? I think you should consider that. The deputy director that you have already postponed the commencement date, therefore there won't be a need for temporary licenses. I don't think you have struck the right balance there, deputy director. After we've postponed the commencement date, I believe the majority of the trade, if they put in the application, they would have already, completed the application procedures. I will not rule out, individual cases which may take longer, and they may not have completed the whole procedure in time. Then, according to the regulation, there will be appropriate measures in place to deal with that. But when we deal with other license applications, we will not be issuing two different types of licenses, long-term and short-term licenses. But if there are individual cases which take longer, we are prepared to consider them. Mr. Gary Chan. Last time, the trade told us that the many of them will not be able to get a license before the end of the year, and their livelihood will be affected. The deputy director said that the waste disposal license application deadline could be extended. Now, I'd like to make a suggestion for the administration. The trade told us that they might take 3 to 5 years, and I don't believe our colleagues would accept that. Personally, I've also said it the last time when I was a member of the Bills Committee on the Private Columbarium Bill, there is also the 3 plus 3 years deadline. So perhaps we can make a compromise and say we can allow 18 months starting from now. So we can allow for a grace period so that up to the 1st of January 2019, then the waste disposal license could commence. Would the government consider my suggestion? And meanwhile, the so-called temporary license, if the applicant wishes to apply for a temporary license, the government should consider that. If a seller has to apply for a temporary license, will they have to also satisfy other requirements? I think we should follow the present procedure. That is, extend the commencement date to January 1st, 2019. I think that would make things a lot simpler, and I'm sure the trade will also will be willing to accept that. Thank you. Thank you, Mr. Chen, for the suggestion. In considering the commencement date, we consider several factors. First of all, from the regulatory perspective and from the angle of enhancing the operation standard, we wanted the commencement date to be in place as soon as possible. The original plan was that the regulatory regime will be put in place by the end of this year, but we understand that the trade takes time to apply for the license. As to by how long we will extend the commencement date, it would depend on how long the trade would need to apply for the clearance. Normally, it would be 18 months. We understand that when the town planning board deals with such cases, it would take about that much time. So we're actively considering this suggestion as to whether or not we can postpone it by 18 months. I also like to add that in our early discussion about temporary license, the intention is not that you need to issue temporary licenses before the commencement date, but rather, if as Mr. Gary Chen said, the application may take about 18 months. And if the town board takes longer than 18 months, in which case will you grant the applicant a temporary license so that he can continue, to operate his business while his application is pending? Chairman, if overall, if we postpone the commencement date, granting a short-term, the need for issuing temporary license will be reduced. But for applications which still being processed, do we need to consider such individual cases? Under the existing legal framework, we do have the flexibility to deal with such individual cases. But as a licensing regime, we do not want to issue different types of licenses. Mr. Gary Chen, I suggest 18 months because there are only 6 months left before the end of this year, and you extend it by another year. If you have to go through the administrative procedures and take a year to do that, I'm sure that will put some pressure on the department as well. If that's the case, why won't you, postpone it to January 1st, 2019? Some members, of course, said that the government is not able to give us a specific date. So does it mean that you don't have 18 months, but rather 24 months or 3 years in mind? So when we resume the second debate of the bill, shouldn't you give members a date? Because we cannot leave it, pending. I think summarizing members' views, it would appear that 18 months would be just about right. And if there are still cases pending after 18 months, and if applications are not yet approved because of the application to change the land use and so on, is still being processed, the department will be prepared to consider those cases flexibly. With these conditions in place, I'm sure we'll be able to allay the concern of the majority of the concern among members of the trade.
Well, I think we note members' comment on 18-month period, and in the future, we need to publish commencement notice for the commencement of the regime, and if I understand correctly, it will be a negative vetting procedure, and we will be consulting the electrical then. And this is definitely not our original policy objective. To defer the commencement of the regime, we'd like to commence it as soon as possible. And about taking a flexible approach, I'd like to emphasize that if there are indeed these cases, as you mentioned, we'll consider how they should be handled. But overall speaking, we'd like to maintain what we propose and under the licensing regime. As chairman of this subcommittee, I'd like to reiterate that this issue is not to be handled by this subcommittee, but we have heard the views and concerns of the trade, and I think that the administration has just explained. I think that they should be able to strike a balance. Next, Mr. Leung Chi-Chang. Thank you, Chairman. I support Mr. Gary Chan's suggestion that there should be an extension by 1.5 years for them to apply for a license. This is, of course, not the scope of this subcommittee, but after passage of this regulation, this issue will inevitably arise, and if we do not deal with the issue, then there will be a problem. because the licensing regime also relates to disposal of e-waste in the future. Of course, the administration has engaged the Alba IWS to dispose of the waste, but I suppose they cannot achieve a 100% rate. And under the licensing regime, the majority of existing recyclers will not be able to operate. So what will be your remedy? Let's say if Alba IWS cannot handle low e-waste, will there be an Alba IWS too? Because this is my concern. Thank you, Mr. Leung, for your question. About the disposal capacity of Alba IWS, we expect the operator to handle 50% of the total waste. We have about 70,000 tons, half of waste, half of them being 85% of them being e-waste. So the government's strategy is to have the public sector replacing private sector. That means the whole trade will phase out. Well, I think we mentioned this point last time. First, it has to do with handling capacity. Mr. Leung's concern was the incapacity of private operators. Well, because I am thinking from the perspective of your strategy. Under your licensing regime, the existing recyclers will not be able to comply with your requirements because you have this land planning requirement that it must be the operation must fall within the industrial zone. But I suppose just a handful of recyclers are currently operating on an industrial site. For the majority of recyclers, they will be folded up without government support, and it is very difficult to have no objection to their operation. This will cause the whole trade to dwindle instantly. You talked about the handling capacity just now, but your strategy, in fact, is to fold up the trade and that your operator can take over. But then, although the land issue will be resolved, many people are going to lose their jobs. I want you to consider whether this is really your strategy, because we're taking a socialist approach as the government undertakes the operation itself. I don't think it's right. Of course, we need the licensing regime and the requirements, but can they really comply with all the requirements within 18 months? That's why I support Mr. Gary Chan's suggestion. You think that land rezoning may be an easy task, but in reality, it's extremely difficult. Of course, for a government department to go through the process is very easy. You can just submit a proposal and let the planning department help you see it through. Deputy Director, as explained before, we are not proposing that the private sector should be taken over by the public sector. For the Alba IWS, well, our idea is that after implementing this new regulation, we want to make sure that the trade has sufficient capacity. But then the trade at the time did not have the sufficient capacity to dispose of the waste. And I think back then we also had a lengthy discussion with members of this council, and we agreed that a facility should be built to ensure that we have sufficient handling capacity. But as I said just now, the facility would only handle 50% of the total e-waste in Hong Kong, and that is why we have this licensing regime, and we also take a flexible approach in approving applications. We consider how much time will be needed for the trade to apply for a license, and we have also considered the existing recyclers who have expressed interest in applying for a license. They have submitted information to us, and it's not really as pessimistic as members believe. in terms of applying for a license or meeting licensing requirements. So I believe that there will be relevant recyclers providing the service in the future. Next, Dr. Edward Yu. I have two questions. First, according to the trade, in terms of land use, I'd like the administration to clarify this point. Industrial land, does it include open storage? I think it'd be very helpful if you can clarify whether open storage also falls within industrial land, because it will allow more operators to operate. And also, does it include the import of e-waste? Because at present, there is no labeling regime for REE sold locally. Say, if we have a label with a telephone number, I can just call this telephone number for collection of the waste. So I want to know whether this will be dealt with under the law. Deputy Director, on land use, we have never specified that it must be industrial land. According to paragraph 4E, we only still provide that the operation must be compatible with the land use. As to whether open storage will meet the requirement, our understanding is that under some circumstances, an application can be made with the town planning board or the planning department for rezoning or conversion. But I cannot say in general whether this definitely will comply with the requirement, because the cases differ. We need to refer to the building plans and also location of their facility and also the planning requirements. No, definitely it should not be interpreted this way. Second point, Chairman, I think it's mentioned in previous meetings whether Alba IWS can dispose of imported e-waste. The answer is no. Now, I think Dr. Yu's question is how we can differentiate waste, e-waste generated locally and imported waste. Well, Alba IWS is the government's contractor, and we also have signed an agreement on their operation. And the Alba IWS will need to collect e-waste, and we will require the operator to keep record with barcodes on each piece of equipment collected, and there will also be a record of the operation from the collection of e-waste to the transfer of waste to the transfer station in Tuen Mun. And by the record-keeping requirement, we can make sure that import e-waste will not be included. I want to know whether contractual agreement is sufficient, because you can just switch the waste. From the model of operation, we understand that the operator will be collecting e-waste from the public, and they are going to develop a computer system to track when and where the waste is collected, and I think that this supporting system will be able to address the issue. And also, there will also be import-export control. Can you also explain that? Well, let me supplement. Apart from this requirement in the contract that the Alba IWS cannot accept any imported e-waste in the future, after the law takes effect, there will be import-export control of e-waste, and the relevant importer will need to apply for a permit for the import of e-waste, and Alba IWS must apply for a permit as well, and it will come to our knowledge. Next, Mr. Wang Teng-Kwong? No? Second round, Mr. Leung Chi-Cheung. Thank you, Chairman. Well, there are 6 categories of waste, electrical and electronic waste. I want to know whether they include electronic components in vehicles. Now, about the 4 types of electric and electronic waste and computers, I think they are set out in the law. How about components in the vehicle? No special requirement on disposal of these components? Chairman, may I elaborate on my answer to Mr. Leung's question? For electronic parts in a vehicle, of course, if it doesn't meet the requirements, it will not be regarded as the REE, whereas on the face of it, for the electronic component in a vehicle, it should not be included in the RE regulation. But why shouldn't it be included? Well, in terms of quantity, the electronic components in vehicles definitely will not be as huge as other kinds of equipment. But say we have electric cars like Tesla, they have all electric and electronic components. If the whole car is exported, then that is fine. But if it's taken apart, then there must be electronic waste. I want to know why they're not included. I recall in the last term, when we examined the proposal, we talked about the types of equipment to be covered, and I understand that there will be a review. Well, in fact, the regulated EE now accounts for 85% of all e-waste. In the future, depending on market development and other factors, we are going to review whether we need to widen the scope. About Mr. Leung's point, such as electronic components in a vehicle, at present they're not included in REE. But for used batteries, EV, for electric in electric vehicles, it is already regarded as REE at the moment, so they are regulated. And let me also clarify, for example, for the radio in a car, at present it may not be covered by this regulation, but there are also other kinds of stereos in the market, and I understand that these car stereos are not covered by the regulation or the levy system at the moment. Chairman, you're correct. For the car radio, it at present does not meet the requirement, and therefore is not a regulated waste.
I fully agree with Professor Yeo. That is, many of the trade are now operating in open storage spaces, and whether or not they get a license will depend on the land use. I'm no expert in the subject, but when the Deputy Director asked a question relating to open storage and land use, my colleague who is the expert does not seem to agree, and my other colleague who is also a user of the open storage land also does not seem to agree. So shouldn't we invite colleagues from the planning department to explain to us if we could resolve the issue relating to operations on open storage, then it would be helpful. I don't know whether or not we will have that opportunity. And secondly, regarding the supervision of Albert IWS, the government told us that you've signed many contracts with them. And in your response today, you say that they should, with 3 days' notice, then they should be able to deal with the waste electrical equipment. So in your contract with Albert IWS, do you provide for any penalties if they fail to comply with the 3-day limit to collect the waste electrical products? The distributors will be facing a major problem. We are granting $150 million to Albert IWS. How do we monitor the operation of this company to ensure that they will properly deal with the electrical waste, and will they also stealthily, import waste electrical products from outside of Hong Kong and dispose of them here? So will we require Albert IWS, will the administration, submit the report from IWS to us for scrutiny. I think what the Bills Committee needs to deal with now is the commencement date and the application procedure. But once we start inviting application, and it's not just land use, other members of the trade also would like to know about how the information they need to know about how when they want to apply a license. So we are still in continuous liaison with the trade to inform them of what are licensing conditions. We will also be telling the trade under what circumstances they will be satisfied. They will be able to satisfy the land use requirements, and if not, then they would need to make further applications. We will step up our communication with the trade. We also have plans to organize seminars or briefings to help them understand how they should, go through the procedures. Of course, in the contract, there are different requirements for ALBA, IWS, and if they fail to meet certain requirements, there will be penalties. Mr. Lai could perhaps elaborate. Mr. Lai. We would require ALBA, IWS to submit an operation plan, and we will also be making random inspection. And after they've disposed with the WEE, they would need to apply to us for payment, and there will be, along each and every step, there will be supervision. We would require Albert WS to maintain a high level of transparency. At the plant, there should be a display gallery, and members of Pt2 and public would be welcome to visit and to give suggestions. Both members of the public and the retailers I think they will talk to the retailers in the light of the market conditions. We expect that after a period of time, the whole system will become mature and will be able to cope with the requirements. All right. If there are no further questions, we will now come back to the clause by clause. Last time we were up to clause 9, which is about the recycling label. So regarding clause 9, do members have any questions? Mr. Chi Fong had some views regarding the Section 9. Let's move on to Section 9. Mr. Chi Fong? I mentioned earlier that the label should be affixed onto the electrical equipment itself. I've actually brought along some energy efficiency labels for examples. If the recycling labels have to be affixed, then it should be the same. The only consideration is the cost for the trade. So my question for the government is that when we first came up with this regulation, what was the rationale for requiring this label to be affixed? I wasn't a member during the last term, but during the present term, when you submitted this regulation, you've told the media many times that the purpose of the label is to enhance transparency. It is for the consumers to be well informed so that the seller will not charge the consumers arbitrarily. And I don't know whether the media has misquoted you. You say that for the REE, our REE will be affixed with the recycling labels. And if the seller were to charge them arbitrarily, the consumers would know. So the whole purpose is to ensure that the seller will not cheat the consumers, and the consumers would know that they've already been charged for the cost of recycling. So the seller will not be cheating the consumers that they have. And secondly, why do you need to ensure there is no fraud, so that people use fake labels. So this is again aimed at protecting the consumer's right to know. And thirdly, after the label has been affixed, what about it's the same kind of equipment bought from outside of Hong Kong which don't have the labels? The consumers will have to consider whether he want to buy it at Fortress or at Taobao. So the consumer will need to make his own judgment. So I shan't repeat the points I've made at an earlier meeting already. The public does not support your proposal to charge for the refuse they produce. And if consumers don't know at all what happened, even if you've charged the producer a levy, the consumers may not know. I gave you an example last time. If I buy a piece of electric equipment and 10 years later the consumer may not remember that there is free delivery, free collection, and so on. So he will simply dump it to the refuse collection point. He will not return it to the producer. He may, sell it give it to another collector. And will these so this is changing the behavior of the consumer. If the label were fixed onto the product, then the consumer can go back to the original supplier who will provide for the free will take away the product. Chairman, I think we've discussed this several times already. Well, I think the consumers, it is important for the consumers to know that when they buy this piece of electrical equipment, a levy has already been charged. So we believe that we need to, adopt this method to inform the consumer whether or not a levy has been charged already. As to how we can achieve the effect, we cannot just rely on the label. In the regulation, we stipulate that in future, when the seller sells the piece of equipment to the consumer, on the invoice, he would need to spell out whether or not the levy has already been paid. We don't believe that the seller would need to affix the label onto the equipment itself. On the other hand, we allow for the flexibility so that when the invoice is issued to the consumer, the label and the invoice could be affixed together and given to the consumer. So it's only a question of how this is given to the consumer. But on the invoice itself, it should be clearly stipulated that the levy has been paid, and the label should also be given to the consumer at the same time, so that he would know that for that piece of equipment, a levy has already been charged. Mr. Hui gave the example of the energy efficiency label. If you compare that under the energy efficiency label on the invoice itself, it is not stated what is the energy efficiency level. So I don't think we need to follow the approach of the energy efficiency label. We are providing two channels to inform the consumers. The important purpose of the invoice, as we said in the last paper, is that on the invoice we don't need to list the levies paid for different electric equipment. We simply say that for this piece of equipment, a levy has been imposed already. But we don't agree with that suggestion. We think we need to make it more explicit and stipulate that what will be the levy charge for each of the REE, so that the consumers is well informed as to how much levy has been paid or charged. Mr. Hui's, the purpose of Mr. Hui's suggestion, I think what we are proposing now would be able to, achieve what Mr. Hui suggested. That is to ensure, to inform the consumer whether or not for this piece of equipment a levy has already been paid. At the beginning, we have considered in that whether or not we should affix the label onto the equipment. The trade has told us many times that operationally this will be difficult. The main reason is that along the whole logistics chain, they want to ensure that there should be a label affixed onto the equipment in each and every of the stages, and that would add to the compliance cost. So we've therefore struck a balance here, on the one hand to ensure the consumer know how much has been paid, and also we have taken into consideration the compliance cost. The Deputy Director said that when the consumer buys a computer or electrical equipment, there will be a clear indication that a levy has been charged for that product. And the seller must provide for a label. The label could be affixed onto the equipment, it may not. But the consumer would find either the label affixed onto the equipment or the label is given to the consumer himself, and he can choose whether to fix it onto the equipment. And secondly, at the time of purchase, when all these procedures are complied with, but the label is not affixed onto the product, and in future when this product will have to be disposed of, will the consumer encounter any difficulties? And if the label is not attached, then at the time of disposal, will the consumer have to pay another levy? Chairman, first of all, the consumer, so long as the consumer can choose to affix the label or not, and how the supplier can either affix the label onto the equipment or give it to the consumer. So the label is a very important means to ensure that everybody complies with the procedure. As to how the label is to be given to the consumer, I think the WTO has a requirement here. To answer your second question, Chairman, that is, if the consumer in future asks for the free, disposal service, now the consumer, so long as he has already paid the disposal charge at the time of purchase, if he has paid the surcharge upstream, the consumer can ask for a free disposal service. At the last meeting, some members asked whether we should only ask the consumer to make that choice a long time after the purchase, but rather when the consumer buys the equipment at that moment. Chairman, Director, I think you must misunderstood my point. I'm not talking about the consumer buying a new electric equipment and the old equipment needs to be disposed of. But let's say I buy a piece of equipment today and 3 or 5 years later I need to dispose of that equipment. At the time of disposal, whether or not the label is on that equipment would result in the consumer having to be charged again.
主席，我諗咧，其實個情況會係咁樣，個法。
Chairman, I think that for the statutory waste disposal or removal service, when a new piece of equipment is purchased, then a free of charge service should be provided for removing the old one. But let's say after buying a piece of equipment, some years later, the consumer finds that another piece of equipment at home should be disposed of, then it's not included, it's not covered under this regulation. But in fact, we are already providing removal service for removing old pieces of equipment, but it's not included in this law. For example, well, if there is an old equipment, a consumer can make use of the community green station or call our hotline for removing the old unwanted equipment, but it's not covered under the waste removal service. Ms. Choi. Well, then according to you, the label will be meaningless. You can just get the invoice and then throw away the label, because whether you have the label or not, they would have the statutory responsibility of removing the waste. Now, the label informs consumer of the arrangement, and under the producer responsibility scheme in the future, for upstream arrangement, the seller will be provided with labels, and they will be required to tell us how many pieces have been sold. But no label is needed. But please let me finish. I think the labeling scheme will allow us to monitor their operation to see if there is any discrepancy in the number of equipment sold and labels distributed. But your understanding is correct. It's not really necessary for the consumer to request for removal service by showing the label. Basically, at the time of purchase, the consumer can decide whether the removal service is needed. Then, according to me, according to you, there is no need to have clause 9. You can just delete it, because you should have a record of how many pieces of equipment you have sold. You have invoices. I don't accept your explanation. Well, at the time of purchase, I have no idea because I cannot see the label. I will only be given an invoice after I have paid. Then, by then, I would know whether a levy has been charged. This is a technical point. The second point, you're going to create a loophole. Let's say if you don't require sticking of the label, then some collectors may collect these labels not attached, and then they would affix the labels onto equipment that are not covered by the regulation, and then they can just resell this piece of equipment, telling the consumer that they can enjoy the free removal service later because the levy has been charged. So how are you going to address this loophole? Deputy Director, about this loophole, I don't quite understand how this situation will arise. I want to emphasize that even for the energy efficiency label, if I understand Mr. Hui correctly, we need to inform the consumer at the time of purchase when the consumer decides whether to buy it or whether a levy has been charged. So regardless of the energy efficiency performance of the specifications, as long as it's a regulated electronic equipment, electrical equipment, then it will be subject to the levy system. So like Mr. Hui said, well, even if the label is affixed onto the equipment, I think there is a big difference between this label and the energy efficiency label, because the energy efficiency label will specify the energy efficiency of this piece of equipment, so that even before making the purchase, the consumer can be given this information. But the purpose of this label is to let the consumer know whether a levy has been charged. Well, there is no need for the consumer to know whether a levy has been charged as long as it's in RE. I think there's a fundamental difference here. Chairman, may I also elaborate on my point? Right, I'll let you go first, followed by Dr. Edward Yu. For the energy efficiency label, I think there is a difference because there are different gradings, and the consumer can choose which grade to purchase. But as for the REE, I think the consumer will also decide if they would purchase the equipment if a levy has been charged, because if the levy has been charged, then it will be more pricey. So as soon as the consumer enters the shop to buy, say, a refrigerator, he has to know whether a levy has been charged, because the refrigerator is becoming more expensive. And that's the first point. Let's say if there is a label, and if through other channels I can buy the same refrigerator without the label, and it's up to the consumer to make this informed choice. Maybe I can buy a refrigerator from Taobao, only that there is no label and I need to pay for waste removal in the future. So what is meant by that? To prevent abuse of the labeling system. If there is no difference at all, then how can you say that you can prevent shop operators from indiscriminately charging more? Well, I think that Mr. Hoy's suggestion is that the label must be affixed onto the equipment, but I think it's provided in the regulation that when a seller sells an equipment to the consumer, a label must be provided. So in the end of the day, the label will reach the hands of the consumer. The only thing is whether we need to specify that the label must be stuck onto the equipment. And having drawn reference to other jurisdictions, we believe that it is not necessary. If my understanding is correct, I think Mr. Hoy is saying that this label is not useless. But then at the appropriate juncture, the consumer should know about this label. But our position is that after the consumer has purchased the equipment, we need to give the consumer the label as well as the invoice so that the consumer knows that the levy has been charged and that free removal service can be provided. Well, I think that in 9.2, it says that the label must be provided. And then 9.3, it says the label is not required to be provided, so on and so forth. But I think that in 9.3, it says that to avoid doubt, the label is not required to be provided by fixing it onto the REE. Well, I think that the text itself is confusing. It seems to suggest that the label is not required at all. You should say that, well, you can say that you encourage the fixing of label, but then it's not mandatory requirement. And then for the wording here, it says to avoid doubt. So does it mean that if I really am to avoid doubt, I should affix it onto the equipment? I understand your point, Chairman. In 9.3, it may give a perception that I should not affix it. Well, you are encouraging people not to stick the label onto the equipment to avoid doubt, because you use the words not required and also to avoid doubt. So in order to avoid doubt, we should not stick the label. I understand the operational difficulty of the trade, but under some circumstances, affixing a label onto the equipment is not really difficult. So I think you should give more flexibility. You can say you encourage doing so, but it's not a legal requirement, and that we can understand your point. But about the text in clause 9.3, I think that you are giving the opposite message. Well, I think that the way it is interpreted may give you this perception. So let's say whether we can delete certain words to avoid doubt, or other phrases that usually appear in other provisions. I think we can consider deleting them or amending the wording so as to avoid misunderstanding that the label must not be affixed onto the equipment to avoid misunderstanding.
好，咁啊，姚松議員都等咗一輪啦，不過就
Dr. Edward Yu has waited for a while, but we have Mr. Eddie Ju here speaking for the first round. Thank you, Chairman. It's an interesting discussion. I'd like to take part in it as well. Well, I was in another meeting about 85% of the government health warning on cigarette packaging, and I think the tobacco manufacturers would ask the same question. I can't design the packaging of my product, but in this case we're talking about sticking a label onto equipment. We're talking about producers' responsibility. It's their responsibility and how much they're willing to take up this responsibility. I think that we can debate on this point. I follow Mr. Ted Hoy's point, and I think he is suggesting that they should take up more responsibility, and that is by affixing the label. because it will help the running of the whole scheme. Now, to follow Chairman's point, to avoid doubt in clause 9.3, can you explain what kind of doubt you're referring to? What doubt will arise? I think that exactly we have doubts in our mind now. Deputy Director, yes, I understand. I think that this phrase "to avoid doubt" is exactly causing everybody to be doubtful. Well, under such circumstances, perhaps we'll go back and see whether we should amend the clause, because the wording "to avoid doubt" may be superfluous. It may even cause doubt. So go back and think about it. Yes, Mr. Adichu. He hasn't answered my question. I don't think this phrase "to avoid doubt" is really superfluous. I think you need to ponder this question. What doubt are we talking about? What responsibility are we talking about? You must think about this point. You must have thought about this point before you put down the second part of the sentence, that the label is not required to be affixed. I want to know whether you have thought it through. Chairman, I just now already set out the background of this issue, and then I can now defer to my colleague to give you more information. When we met with the trade, when we suggested affixing the label onto the equipment, what was the trade's views? Mr. Lai. I think we need to provide more detail, because in 2012, when we conducted the consultation, the government analyzed the experience of different jurisdictions in Europe and in Japan. And in Japan, their experience was unique. They have piece of legislation on waste disposal, and that is to say the equipment must come with a label affixed before the equipment can be sent to a facility for treatment. And the discussion was whether the similar approach would be adopted in Hong Kong. As we discussed with the trade on the principal legislation, according to the paper in our earlier business impact assessment, it was already indicated that if we require labels to be affixed onto equipments not covered under the RE regulation, including the energy efficiency label, the trade would experience difficulty. So in 2012, when the consultation came to an end, the government's position was that the label should be provided, but we would not require to be affixed.
The ordinance said that the label only need to be provided. In the regulation, we had to consider whether or not this has to do with the waste disposal ordinance in Japan. So even if the label doesn't have if the equipment doesn't have a label, will there be a charge when it's taken to the disposal facility? Well, actually, the purpose of our policy is that so long as the label is given to the consumer in any way at all, it will satisfy the requirement of the regulation. And if possible, we encourage label to be affixed onto the product so that the consumer is informed. But we have submissions from the industry that if this is the requirement, they will not be able to comply. So for the REE products, and given that the ordinance and the regulations now seem to have, balanced the consideration of the different parties, could you say that the register supplier can affix the label onto the equipment itself, or the person who has the right of custody over the product can fix it. So at least you should spell out clearly that the label should be affixed instead of encouraging people not to affix it. As to the person who is in possession of the electrical equipment after he has obtained the label, whether or not he is compelled to affix a label, I think we should allow for some flexibility here for the consumer. But after this is well known in the market, I'm sure people will probably affix it onto the computer or the equipment after he has bought it. Because when you sell the product, you would have to, allow the consumer to inspect the product before he takes delivery, at which time you can affix the label. But since the trade has raised its concern, I'm sure they may have their own operational difficulties. But if that's the way you draft the regulation, and in order to allay our concerns and to ensure that the consumers know that the government is encouraging recycling, and that the government is encouraging want to ensure that we can do the good job in terms of imposing the levy and so on. Well, we've heard members' views. I believe that members would like to have the flexibility, but we should give the false impression that we don't want people to fix the label. We will see how we can tidy up the terminology so that we can send out the message more clearly. But still, eventually, this is a provision in the law. So perhaps through discussion with the trade, we can, come up with a solution. So perhaps we can go back and take a look at how we can further tidy up the drafting of 9 Bracket Street. Professor Yield. I'd like to follow up on my earlier point. I'd like to use an actual example. I asked a question about possible swapping of the products. If I'm a parallel trader, whenever I travel abroad, I buy 2 PCs. The producer is in another countries. When I come back to take the product back to Hong Kong, I've attached the labels onto the computer. How would Alba IWS know that this product is bought locally or overseas? Because the computer is bought overseas, but it's attached to the label. How do you resolve, disputes like that? Chairman. Now, I think in previous bills committee, it has been asked about, electrical equipment bought outside of Hong Kong or bought over the internet for self-use rather than for distribution. Will the consumer also have to pay a levy? I think we've discussed that point before. If you buy a PC online, the consumer doesn't need to pay the levy. But as to whether the regulation will have any extraterritorial, effect, I don't think there will be any. The focus here is whether the label will be abused and whether or not it can help us, supervise the collection of waste electrical products. Is it that we only collect equipments with labels and we don't collect those without labels? But the consumer is not required to fix a label. We cannot just rely on the label to ensure that Alba WS will not import waste electrical products from abroad. So there will be barcodes so that we can check where the product is being collected. And I think Mr. Yu is also very concerned that we want to ensure that foreign electrical waste product will not be imported in Hong Kong. So we have the import-export license regime to monitor that. I think that would be more effective. And it's not that the label will enable us to do a better job in this regard. So are you confirming that the products which are parallel, imports cannot be regulated? That is, they appear to be locally, bought, but they're not actually local products. Well, I think in Hong Kong we don't manufacture electrical products, yes. But during the last term, when we discussed this issue, it was suggested that it was asked whether or not these electrical products bought overseas would they be legal. The answer is not. Your question is whether or not IWS will also, dispose of these electrical equipment bought outside of Hong Kong. Now, right now, we already have some old electric equipments which have been bought before the commencement of this regulation. And even now, they would also IWS would also dispose of electrical equipments from outside. You talk about import-export control. You're regulating, people who actually import large quantity of waste electrical products. But what happens if somebody claims that these equipments have been brought into Hong Kong, one piece at a time, but in fact it's not. So they import these in large quantities and they can bypass your import-export control. So there is this loophole here. The person can claim that these are, parallel imports, and you will still dispose of them for them. So your law will not be able to deal with large quantities of these waste electrical products imported in Hong Kong and it's being claimed that it's not imported in large quantities. If the supplier has to distribute certain electrical equipment, the REE products, that is, even if they were imported piece by piece through online procurement, he would still need to pay the levy. The law already provides for that requirement. As for the label, and how that help us, implement to ensure the supervision. I think last time when we deliberated on this regulation, the question was asked that if you're a supplier and you were a consumer, there's a difference. For the supplier would need to enforce the conditions of the regulation. But for the consumer, if he buys a product overseas or on the internet, would that be illegal? The answer is no. And it's difficult to require the consumer to register himself as a supplier and pay a levy and apply for a label, right? Right. Because Section 9(3) has given rise to a lot of concerns, I would suggest that you go back and consider how you might tidy up the terminology so that you can clearly spell out the spirit. I understand members are considering to move an amendment here. But it's not easy to move an amendment on this issue because it's quite complicated. We would need to ensure that operationally it is possible and that we can really achieve the purpose of producer responsibility and to ensure that the consumers are better informed. Now, see, the administration is working on the bill for such a long time. It will be a lot easier for you to move the amendment yourself rather than for members to do that. If you are able to allay our concerns, I think we will be happy to accept the amendments that you will move. I will not be long-winded, Chairman. To sum up, I'm worried there might be some misunderstanding. My position is very clear. I don't think you should allow for any flexibility. So my point is that the label must be affixed. That's my position. So my amendment will be very simple. Yeah. I will simply move an amendment to say that the label must be affixed. Well, there will be another meeting yet, so perhaps we can discuss this at our next meeting. After we're finished with the scrutiny of the regulations, we have to consider whether or not there need to be a CSA. The government, of course, can move a CSA. Members can also do that. As to whether or not the CSA should be moved by this Bills Committee, it would depend on whether we all agree with that amendment. So we'll leave Section 9 pending, and the administration has promised to go back and see how they can tidy up the drafting of 9(3). Let's move on. Mr. Lai. Chairman. Next, subdivision 2, returns. This is section 10 to 15. In the ordinance, it is stipulated that the suppliers have to submit periodic returns. Section 10 stipulates that the return must be submitted to the director in specified form. 11 stipulate that the return must be submitted once every quarter. That is January to March, April to June, and so on. For short-term registration, the maximum will be only for 30 days, and only a single return will be required. And Section 12 is about the reporting period. So, for example, what happened when the registration is revoked and so on. Section 12, reporting period, this only provides for the technical definitions. So, if it is less than 3 months, how do we interpret the reporting period if it is fewer than 3 months? And what should be the content of the report? Section 13. On the last day of the returning period, then a return must be submitted within 28 days after the last day of each reporting period. Section 14. Content of returns. The return must contain the number of electrical equipments imported and exported, and we will calculate the levy according to the quantity. So that's subdivision 2. Any questions? If not, please move on. Subdivision 3, records and documents relating to returns, section 15. This is to require the supplier to keep records, invoices, and so on, so that there could be proper audit trail when we conduct the audit later on. Subdivision 4, audit reports. For the quarterly returns, they should be subject to an annual report. Section 16 to 21 about the operational details for the audit reports. In Section 18, it states that an audit report must cover a return if the reporting period of the return falls within the relevant audit year. And within 3 months before the end of the auditing period, the audit must be submitted. And the audit has to be prepared by a practicing accountant or auditor. After the auditor has gone through the whole accounts, in Section 20, we require the auditor to give his opinion. First of all, to state that the registered supplier has kept records, and 2, that the return has been prepared in accordance with such records and documents, and thirdly, the quantities of regulated electrical equipment reported in the return has been reported in accordance with the law. If the accountant could provide such an audit opinion, then regarding the report on the REE distributed, then the report would be regarded as in compliance. Now, there would also be provisions regarding omissions and discrepancies. In 22, we provide for, so there is actually a section under 23 about discrepancy. A discrepancy list would be has to be prepared, and 21 is about exemptions. The trade has told us that they will incur some costs if they have to conduct an audit. So what is the financial year for the audit period? The trade would like to have some flexibility, whether or not the audit year should start on April the 1st or June 1st. So they have a choice of 4 dates, and the trade is satisfied with that flexibility. But if the cost of the audit and compare with the levy they have to pay, if it's out of proportion, then we have to consider the question of compliance cost. In 21, we say that if the levy is less than $20,000, an application could be made for an exemption.
And it should be submitted within 1 month after the last day of the relevant audit year, and we'll consider exempting the auditing requirement. Next. Subdivision 5, Recycling Levies. Sections 22 to 26. Section 22 prescribes the amount of recycling levy per item of REE and is set out in Schedule 1. Earlier, we already reported to the panel that the cost recovery principle should be adopted, and then the amount will range from $25 to $156. And the next section has to do with the payment notice, because after receiving the records on how many pieces have been sold, we will calculate the payment of recycling levy and issue a payment notice. And in Section 23, it says that the payment must be made within 30 days after the day of issuance of the payment notice. Section 24, payment on assessment notice, because in the ordinance we have this mechanism. If someone is required to pay the recycling levy payable, and that person may, for various reasons, not have paid the levy, we will will issue an assessment notice to assess the levy to be paid, and again the payment is to be made within 30 days after the issuance notice issued. Section 25 about the discrepancy list. If in the process of audit it is found that the number of REE reported has a discrepancy, then in the next cycle we will refer to the discrepancy list in calculating the amount. However, we also envisage certain scenarios. For example, if it's a last time supplier reports the return, and if it is found that the payment has been made in surplus, then according to Section 26, the overpaid recycling levy will be refunded. So that is about the operation and collection of recycling levies. Any questions? No? Please continue. Part 3 relates to the responsibility of sellers. Division 1, recycling labels and receipts. We provide in the ordinance that if a seller distributes REEs, then the seller should provide the recycling label of an equipment and the receipt. I think Section 27, recycling label, is also the same as Section 9.3, and that will consider both provisions. Section 28, receipt. The receipt should expressly provide the payment or the collection of a levy so that the consumer will be informed, and the requirement is that the receipt must contain wording in both English and Chinese, and the wording is set out in Schedule 2. In our response paper, we also mentioned that there are suggestions whether the wording set out in Schedule 2 can be made more succinct, and we have struck a balance, and we believe that we should remain status quo, and that's the part about sellers. Division 2, arrangement for removal services. Subdivision 1. After the regulation takes effect, a seller must submit a removal service plan endorsed by the EPD, and the plan should be submitted according to the specified form, and there will also be assistance for the trade to complete the application for endorsement of plan. We'll follow up with the trade on this matter. And Section 31, we have received some comments. Our proposal is that for the removal service plan, it is stipulated in the ordinance that 3 collectors and must be specified, and one of them must be the default collector. And according to the trade's views, there are peak seasons during the year, and there are difficulties in terms of their logistics arrangement, and that is why we're going to submit an amendment to specify that there should be not more than 5 collectors, and also if none of the collectors can provide the service, the seller itself can also provide the removal service. And with the support of the subcommittee, we are going to move this amendment. I think the legal advisor has a question, Lee. Thank you, Chairman. We're on Section 31, subsection 1, and I'm referring to 1B. It says that the undertaking under Section 41(3)(a) or B of the ordinance must be made in the specified form. Now, if we refer to Section 41(3)(a) and B of the ordinance, they are 2 different forms. One is that the collector should make the written undertaking to the seller, and the other is for the recycler to make a written undertaking to the seller. So I want to know whether you will delete the word "or", so that you can cover both undertakings under this, and replace "or" with "and", so that you can cover both undertakings. Thank you, legal advisor, for your comment, but I don't think we're going to accept the legal advisor's proposed amendment, because we are suggesting that regardless of the undertaking made under Section 41(3)(a) or B of the ordinance, it must be made in the specified form. And that is why we don't think that the amendment proposed by the legal advisor is necessary. Any response from the legal advisor? Well, my take is that to avoid doubt, you should use the word "and" or. But if the Department of Justice believes that the doubt has been addressed, then I'll see what members think. I don't think we have strong views on that, right? Section 31, subsection 2. For the removal service plan, the default collector is required to do certain things. For example, in relation to the classes of REEs distributed by the seller, and the collector should be able to provide removal service and also to collect the equipment on any premises in Hong Kong. Next, the director may refuse to endorse a plan for various reasons. For example, we need the application to be made in a specified form if the endorsement application hasn't been made in the specified form, or that if the applicant has already applied for an endorsement plan, and then another application should not be made, but rather an alteration of the plan should be made. And these are grounds of refusal of endorsement of a plan. And after the approval or endorsement has been given, the director will inform the applicant in writing. That's section 33, section 34. If the application is refused, the director must give notice to the applicant in writing and state the reasons for the decision. Subdivision 2. Let's say the endorsed plan has to be changed. For example, if the seller wishes to change the collector, what we should do? Well, since the law requires an endorsed removal service plan, we are going to make a special arrangement here. There should be sufficient notice for us to process the application, and we require at least 30 days before the change. However, if all of a sudden the collector has ceased operation and that the seller has to appoint another collector, we can make a special arrangement. On receiving the application, we will give acknowledgement receipt to the applicant stating we have received the application and will process the application as soon as possible. But let's say if the applicant has not received any notice from us and it is taken that the application has been processed, such that the change will also take effect and be regarded as having met the requirement. If the application is made out of time for some reason, then we may consider waiving the 30-day requirement. For example, if the collector has ceased operation and that we may not be able to, it may not be 30 days before it ceases operation, and we'll consider waiving the 30-day requirement. Any question, Mr. Hui? Can the administration explain this? In Section 9 and Section 27, what's the correlation in terms of the labels? Sections 9 and 27 refers to the recycling label. Mr. Lai. This section refers to at least two tiers of the chain of supply, that is the supplier and the seller, and the supplier could be the manufacturer or the importer, and the supplier supplies the equipment to the local market, and then at the next level it covers a wide scope. It can be a seller or distributor or wholesaler before it reaches the next tier, retailer. So for Section 9, referring to the supplier, when it is first supplied, then the label should be provided. Then it can go through either a wholesaler or a retailer, because you can use a distributor or a wholesaler first, and that is for Section 9. Whereas for Section 27, the label should be provided once an equipment is available in the local market, and then the label should be passed on to the retail level, and that is the seller in Section 27, because in Section 27 the seller is responsible for providing the label to a consumer. I think that these two approaches are similar. So whether a label should be stuck onto the REE, well, I think that wouldn't it be more feasible if we require the label to be stuck in Section 27 instead? Because for Section 9, you already explained the difficulty of suppliers. It's difficult for them to open the boxes of equipment and stick the label onto them, because the supplier does not directly sell the equipment to the consumer.
係去到直接同消費者嗰個銷售嘅時間，咁係銷售者係取得呢個。
At the point of sale, when the consumer acquires or takes control of the electrical equipment, at that time a label definitely would be given to him. if the label had to be affixed onto the product, it should be possible, because anyway the consumer will need to open the box and check the product and then take away the product. So while it may not be necessary under Section 9, but under Section 29, operationally speaking, it is possible to require the label to be affixed. For different products and different labels, the situation will be different. For the retailers, for certain popular products, the supplier might have already the stock in place, and then they will distribute the products through their own logistics service provider. But sometimes it is the supplier who will supply the products. Sometimes the consumer will take the product away from the retail outlet, but sometimes, the retailer buys the product, but the product is, transported by a courier. By the time the box is open and the product is to be assembled, that would be the final stage of the. But if all the products are delivered to the consumer like that, then of course it's possible. But in some cases, it's not like that. I understand you don't agree that the fixing of the label should not be mandatory. But at the upstream, if the label were already affixed, then you don't need Section 29. Section 29 says that you don't need to affix a label. You just want to ensure that the label is handed to the consumer at the last, stage. Well, there are different brands of products and the products could be produced in different countries. Chair, I don't need to debate over this point. I'm talking about the relationship between Section 9 and 27. We need to differentiate between the two because of the reasons you gave just now. If the label were affixed pursuant to Section 9, then we don't need 29. Section 9 is about the registered supplier. 27 is about the seller. So they actually belong to different parts of the supply chain. So I think the administration is well aware of the concerns of members. Perhaps you can go back and see how you can, tidy up the wording to allay members' concern. Next, Part 3, matters related to sellers. And that is request for removal service. And the requirement already spelled out in the ordinance. That is, according to the terms of free removal, the seller should provide for the free removal service. And under 1B, we say that there should be a time limit. 3 days after the limit should be 3 days, the time limit. But the trade said that this may not be realistic, because when you buy an electric equipment, the seller may have to go through the procedure and make the record and so on. So we therefore propose to amend this section. That is, at the point where the contract is distributed, because very often for the seller, regarding the free removal service, the seller must keep records so that in respect of each product or transaction, there should be a record. For example, when the products are distributed, the serial number of the product, the nature of the product being purchased, whether the service is required, where the product is delivered, where free removal service are provided, there should be records so that we could, check and follow up when there are complaints. Sometimes the information under Section 41. There are many such information required, and if any information is missing, then the supplier would need to provide for the missing information to comply with the requirements. And we've consulted with the trade, and they also find these requirements acceptable. I'd like to go back to Section 40, requests for removal services in the manner specified by the seller. Could you give me some example? How could the request be made? In the ordinance, this is in Section 42 of the ordinance. Section 42 bracket 40, subsection 2. When the seller distributes the REE product to the consumer, according to the terms stipulated by the seller, when delivery is made, there are certain conditions. For example, the consumer can request for delivery by phone or in writing. So there will be arrangements in place. And these could be spelled out, under the terms or removal services, including, for example, the time limit. So this would tally with the ordinance. So I may not be very clear here. Let's say the equipment has been purchased for a long time. I want the product now to be removed. When should I make the request? That is not a statutory removal service. The amendment we're proposing here is that if removal is requested, it should be removed. The product should be removed immediately. If somebody bought a new equipment and there's no need for removal service immediately, so we're saying that IWS should keep a hotline, and we are promoting recycling of WEE products through the territory, and we've been, for example, conducting a recycling campaign during the Chinese New Year, and the licensed recyclers, I'm sure, will provide for similar services. So that would not be under the legal so you're not talking about immediate requests. So the request could be made immediately, maybe 1 or 2 days after the purchase. But Chairman, I think this is a response to the discussion at the last meeting. It was suggested the consumer should make the request 3 days after he has received the product. So if we allow the consumer a few days to consider, would that make things more complicated, and will we be hurting the interests of consumers? As I said, in the majority of cases, the consumer will, at the time he buys the product, will also consider how the product will be disposed of later. Well, I think you can keep the flexibility. Originally, the consumer may not want to dispose of the old product. When it goes home, he changes his mind and want to dispose of it. So if the consumer doesn't make up his mind at that time, then he will forsake the right. Well, it could be immediate or no longer than 3 days. Those are possible options. It's all a question of balance. Yeah. So if members think that it shouldn't be immediate, we can go back and consider, that we should provide for time limit. I don't think you should rule out the possibility that the consumer will only consider dumping the old electrical product 1 or 2 days after he bought a new one. And if he doesn't make a request immediately, he shouldn't automatically be forsaking that right. Well, I think we will need to schedule one more meeting to deal with the remaining sections. Anything else on Section 41? If not, we are left with Part 4 miscellaneous. Could you go through that very briefly, Chairman? Part 4, Division 1, specify forms. That is, the director may specify forms and how these forms are to be used, what are the requirements. So that those are the provisions under 43. 44, electronic records as specified forms. So we will allow for certain records to be stored in electric forms. Division 2, other matters. Section 45, rights of appeal to the appeal board. 46, extension of periods in the event of black rainstorm, public holidays, and typhoons, whether there should be extension of 1 day or bringing it forward for 1 day. And Schedule 1, amount of recycling levy. Schedule 2 would be the wording contained in receipts. Thank you. So that's the regulation. It's almost time for us to adjourn. We have now basically finished the scrutiny of the regulations, but there's still a few more issues outstanding. So the administration will need to go back and consider whether they want to move any CSAs. Earlier on today, you've said that you will be moving some CSAs. And also on the subject of whether or not the label should be affixed, different members have different views, so you may need to work on that. On June the 9th, we will have our next meeting. We will be discussing the amendments that you'll be moving to us. Would you have enough time for that? I think we should be able to wrap up everything on the 9th. I think we should be able to do that. Legal Advisor, thank you. If the administration wants us to discuss the text of the CSA on June 9th, I hope they will be able to give me the copy of before that. Yes, certainly. Our legal advisor will need to look at your CSAs before the meeting. In respect of the notice, I have not heard any members saying that they want to move any amendments. If you want to move an amendment, now we have now extended the deadline to the 14th of June, so I need to report to the House Committee regarding the scrutiny of the notice. And it's well, basically, we're finished with the scrutiny of the regulations, but there's still a few outstanding issues, and we still are waiting for the CSAs from the government. So on the 9th of June, we will be holding another meeting. This afternoon, I'll report to the House Committee about the scrutiny of the notice. If our target is to wrap up our discussion, our scrutiny of the regulation on the 9th of June, when would the government want us to go to the council?
Well, because we need to give notice for members to move amendments, we need to consider that. Well, we want to work on it as soon as possible. Once the subcommittee completes its work, we would like to table or resume the second reading of the bill in the council as soon as possible, because we need to give notice to amend the regulation. We'll report to the subcommittee later. Well, we're about to conclude this meeting, so meeting's adjourned, and I'm going to report to the House Committee our work on scrutinizing this notice. Thank you.